Be ready. Start. Section 397 of the Code empowers the High Court or the Sessions Judge to call for and examine the record of any proceeding before any inferior court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety inter alia of any order passed by such inferior court. The powers of revision are concurrent with the High Court and the Sessions Judge. By virtue of Section 399, the Sessions Judge may exercise all or any of the powers which may be exercised by the High Court under subsection 1 of Section 401, and while doing so, the provisions of subsections 2, 3, 4, and 5 of Section 401 apply to such power as far as possible. Section 202 of the Code has twin objects. 1. To enable the magistrate to scrutinize carefully the allegations made in the complaint with a view to prevent a person named therein as accused from being called upon to face an unnecessary, frivolous, or meritless complaint, and the other to find out whether there is some material to support the allegations made in the complaint. The magistrate has a duty to elicit all facts having regard to the interest of an absent accused person, and also to bring to book a person or persons against whom the allegations have been made. To find out the above, the magistrate himself may hold an inquiry under Section 202 of the Code, or direct an investigation to be made by a police officer. The dismissal of the complaint under Section 203 is without doubt a pre-issuance of process stage. The Code does not permit an accused person to intervene in the course of inquiry by the magistrate under Section 202. The legal position is no more res integra in this regard. Section 200 contemplates a magistrate taking cognizance of an offence on complaint to examine the complaint and examine upon oath the complainant and the witnesses present, if any. If on such examination of the complaint and the witnesses, if any, the magistrate, if he does not want to postpone the issuance of process, has to dismiss the complaint under Section 203 if he comes to the conclusion that the complaint, the statement of the complainant, and the witnesses have not made out sufficient ground for proceeding. Per contra, if he is satisfied that there is no need for further inquiry and the complaint, the evidence adduced at that stage have materials to proceed, he can proceed to issue process under Section 204 of the Code. Section 202 contemplates postponement of issue of process. It provides that if the magistrate, on receipt of a complaint, if he thinks fit to postpone the issuance of process against the accused and desires further inquiry into the case, either by himself or directs an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding, he may do so. In that process, if he thinks it fit, he may even take evidence of witnesses on oath, and after such investigation, inquiry, and the report of the police, if sought for by the magistrate, and if he finds no sufficient ground for proceeding, he can dismiss the complaint by recording briefly the reasons for doing so as contemplated under section 203 of the code. But after taking cognizance of the complaint and examining the complainant and the witnesses, if he is satisfied that there is sufficient ground to proceed with the complaint, he can issue process by way of summons under sections 204 of the code. Therefore, what is necessary or a condition precedent for issuing process under section 204 is the satisfaction of the magistrate either by examination of the complainant and the witnesses or by the inquiry contemplated under section 202 that there is sufficient ground for proceeding with the complaint, hence issue the process under section 204 of the code. In none of these stages, the code has provided for hearing the summoned accused for obvious reasons, because this is only a preliminary stage and the stage of hearing of the accused would only arise at a subsequent stage provided for in the latter provision in the code. Before issuance of summons, the magistrate should be satisfied that there is sufficient ground for proceeding with the complaint, but that satisfaction is to be arrived at by the inquiry conducted by him as contemplated under sections 200 and 202, and the only stage of dismissal of the complaint arises under section 203 of the code, at which stage the accused has no role to play. Thank you.